All right. Hello, everyone, and thank you for attending today's webinar. Before we begin, we wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer these during the webcast, but if a fuller answer is needed or if we run out of time, we will answer it later via email. If you experience any technical problems during the webinar, those can also be reported through the Q&A widget. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the help widget at the bottom of your screen. Today's CLE is accredited in California, Illinois, and Texas for 1 hour of general credit, in Missouri for 1.2 hours of general credit, and in New York for 1 hour of professional practice credit for experienced and transitional attorneys. CLE credit is awarded based on full attendance. To verify engagement, secret words will appear in multiple choice polls during the webinar. Please respond to these polls to ensure you receive full credit. We value your opinions and appreciate your participation in this course. So today's course is part of the Thompson Coburn HR Law webinar series called Being Resourceful. And we are talking today about employee benefits. I am Amy Stansfield. My partner, Michael Lane, is also presenting today. And we're going to be covering kind of a general employee benefit update from the past year for you. So with that, I'm going to hand it over to Michael for our first topic.
Great, thank you, Amy. First up today is a recent Supreme Court case that has bearing on your defined contribution 401k or 403b plan, as the case may be, and potential for changes in how litigation is handled as it relates to those plans. So the case is Cornell versus Cunningham. It involves a class of current and former employees of the university who participated in defined contribution plans that were sponsored by the university. They happen to be 403b plans, but the relevant law is equally applicable to things like 401k plans if that's what you have at your company. The suit was filed in 2017, and the allegations were that Cornell and the other plan fiduciaries caused the plan to engage in a prohibited transaction with record-keeping service providers. Essentially, they were saying that they paid substantially more than reasonable record-keeping fees for the services that they received. As background, ERISA essentially prohibits all transactions between a plan and a party in interest. Your service providers are going to be your parties in interest, and generally, services required to run any plan would run afoul of this rule if there were not exemptions. The biggest exemption that's relied upon most commonly in these situations is what we call the service provider exemption. There are lots of other statutory exemptions that are available to get out of the prohibited transaction regime, but the service provider exemption allows plans to conduct their administrative tasks and provide compensation to the service providers who are doing those tasks using plan assets, as long as no more than a reasonable fee is paid. The key issue in the Cunningham case is what facts a plaintiff has to plead to demonstrate that the service provider exemption is not available. In this case, Cornell moved to dismiss, and the district court agreed. They said that there were no factual allegations in the complaint regarding the availability of Cornell's reliance on the service provider exemption. The Second Circuit went ahead and affirmed what the district court did. They ruled that plaintiffs must plead that a transaction was unnecessary or involved unreasonable compensation to survive a motion to dismiss. with that Second Circuit ruling, we had what is known as a circuit split, where one circuit court, the Court of Appeals, rules one way, and another circuit court rules a different way. And in this case, the different ruling was from the Eighth Circuit in the Braden versus Walmart case, where the Eighth Circuit ruled that a plaintiff need only plead the elements of a prohibited transaction. The Second Circuit, in contrast, said that you needed to affirmatively plead to survive a motion to dismiss. So now that we've got different courts in different parts of the country ruling in different ways on the same issue, it was right for the Supreme Court to step in and sort of resolve this conflict. And what the Supreme Court said is that under ERISA, you've got three elements to show that a plan was engaging in a prohibited transaction. So they caused the plan to engage in a transaction. The fiduciary knows or should know that it's a direct or indirect furnishing of goods or services or facilities between the plan and the party in interest. In order to state a claim in these circumstances, the Supreme Court said that a plaintiff need only plausibly allege the elements of a prohibited transaction without addressing the exemptions that are available under ERISA. The statutory exemptions, according to the Supreme Court's reasoning, are set forth in a different section of the statute than the prohibited transactions themselves. And so they ruled that statutory exemptions, like the service provider exemption, are affirmative defenses that must be pleaded and proved by the defendants who seek to benefit from them. So in other words, the defendant plan fiduciaries, and not the plaintiff, must address the prohibited transaction exemption. So what does this mean for plans going forward? Well, primarily the concern with this ruling, while well-reasoned, is that it could risk increased or costlier litigation. The reasons for that is it's easier to plead a prohibited transaction, and merely alleging that a prohibited transaction took place is enough to survive a motion to dismiss. So if you get past the motion to dismiss point in a case, you're going to start incurring more substantial costs with the litigation dragging on and potentially discovery starting. You could have situations where the plaintiff's bar jumps on this and files a lawsuit alleging a prohibited transaction to seek settlements. And while some of these cases may or may not have merit, the risk is that potentially folks may file these suits in frivolous circumstances, hoping to get a settlement to get out of the litigation, since it can no longer be easily dismissed at that stage. And there's also risks of interpretations of these new standards by different courts around the country. Once the law changes and the Supreme Court weighs in, then the lower courts are going to have to interpret what the new rules are, and that may lead to some uncertainty in the interpretations of this new standard here. So what can you, as a plan sponsor, or a defendant in one of these litigations, expect going forward? One thing that the Supreme Court, pointed to was Rule 7 in federal courts, which gives the courts discretion to require a plaintiff to reply to a defendant's answer and put forth specific, non-conclusory factual allegations showing that the exemption does not apply. This is something that the Supreme Court has endorsed in the past, but it is not a very commonly used procedure. But given the fact that the Supreme Court specifically called this out as part of its ruling, it may be more effective in these cases if you, as the defendant, can ask the court to invoke Rule 7 to force the plaintiff to come up with some actual facts to support the mere allegations that they may be making in these cases. In addition, plaintiffs also still need to plead injury to establish standing. So they need to show how they were damaged by the action that is alleged to have been prohibited by ERISA. There's also the fact that Rule 11 can be available to impose sanctions against lawyers who file complaints where the exemption obviously applies and the plaintiff and the counsel lack a good faith basis to believe that the service provider exemption doesn't apply. In addition, ERISA does give courts discretion to award prevailing party attorney's fees. So if you're ultimately successful in ERISA litigation, it's possible for the court to order that your attorney's fees be covered by the losing side. It's not very commonly used against plaintiffs in ERISA, but it is certainly possible that if courts are being overwhelmed by cases that ultimately are going to be resolved in favor of the defendants, and they see that potentially these things might be frivolous, they have the discretion to step in and potentially slap down over-aggressive plaintiffs' attorneys who may be filing these types of cases. So an interesting thing to watch. Hopefully the courts are able to handle this new standard without dragging folks unnecessarily through costly litigation and discovery. And now I'm going to turn it over to Amy to talk a little bit about some issues relating to prescription drug programs in your medical plan.
All right, thank you. So as Mike said, our next topic is prescription drugs, and we're going to be looking at a few different aspects related to prescription drug coverage. We're going to look at some state legislation that's been kind of popping up that has to do with prescription drug coverage under your plan, particularly self-insured health plans. We're also going to look briefly at some federal legislation that's in the works. And then we're going to talk about litigation that's popping up for prescription drug plans being filed by participants against plan fiduciaries. So lots happening on this front and lots to talk about. So as we delve into state legislation that concerns prescription drug coverage, I think it's helpful to kind of set the stage with a little overview of ERISA preemption and how ERISA preemption can come into play with state legislation that impacts either directly or even indirectly self-insured health plans that are governed by ERISA. In 2020, there was a Supreme Court decision in the case Rutledge v. Pharmaceutical Care Management Association that is kind of our most recent Supreme Court case reiterating the ERISA preemption standard. So this case had to do with an Arkansas law called Act 900 that set forth various pricing requirements that pharmacy benefit managers operating within the state of Arkansas had to meet in order to operate in the state. As you can anticipate, the pharmacy benefit managers did not like this law. They did not like the pricing restrictions that it set forth. And they argued that it was preempted by ERISA. And the Supreme Court disagreed. So the case, again, it reiterates sort of the most recent status of the ERISA preemption standard, which is that ERISA preempts any state law that either has an impermissible connection with an ERISA plan or that refers to ERISA. So what does an impermissible connection with an ERISA plan mean? It can mean that it interferes with nationally uniform plan administration, which again, ERISA is one federal law that seeks to apply to everyone, whereas state laws only apply to what's happening in that state. So it can be burdensome to have to comply with 50 different states' requirements. We want plan administrators to just focus on ERISA as one federal law. It is also impermissible if it seeks to regulate a key matter of plan administration. Again, we want to look to ERISA for that, not to 50 different state requirements. So that's the standing. Again, the state or the Supreme Court in this case sided with the state and let this law stand. I think it's important to remember that this law, it really was focused on pricing prescription drugs, so it's a little bit different than the laws that we're going to talk about here in a minute. And it didn't have any sort of direct bearing on health plans, particularly self-insured health plans. It sort of indirectly had some correlation with them, but it wasn't a direct directly trying to regulate or control those plans. So as we're talking about some state legislation that's popped up recently in the last couple of years, there's a lot of states that have laws in place for pharmacy benefit managers. There's licensing requirements, there's enforcement mechanisms in place, and these states have these in place similar to insurance laws. And that in and of itself is nothing new. But in the last couple of years, states have gotten a little bit more aggressive in the scope of these laws. And in doing so, we're seeing just very recently, especially in the last few months, these laws are starting to kind of pull in self-insured health plans that are otherwise governed by ERISA into their sort of enforcement scheme. And that raises the question of ERISA preemption. Are these state laws getting to the point where they are preempted by ERISA? Or are they more similar to the state law in the Rutledge case? So it's a question to be seen. These laws are just sort of popping up. So we wanted to talk through a couple of them today. We're going to be talking about Arkansas and Florida. These are not the only two states that have these types of laws, but they're kind of two good examples for us to talk through today. So in Arkansas, we have the Arkansas Pharmacy Benefits Manager Licensure Act, which is, again, is just the state's sort of general licensing legislation for pharmacy benefits managers. It authorizes the Arkansas Insurance Commissioner to adopt rules to implement the act. And under that authority, we have Arkansas Insurance Department Rule 128, which applies to health benefit plans and requires them to submit a report to the Arkansas Insurance Department to ensure that pharmacy benefit managers operating in the state are upholding the network adequacy requirements set forth in the act. So it's an act trying to regulate pharmacy benefit managers, but it's placing a reporting requirement on self-insured health plans as a means to achieve that end. So this applies to any health plan that has any covered lives in the state of Arkansas. So it doesn't matter if where the employer is headquartered. It doesn't matter what the status of the plan is. If there's even a single covered employee or dependent in your plan residing in Arkansas, the plan could be subject to this reporting requirement. Just to give you a snapshot of what these reports look like, there's two different variations. One is for plans with less than 5,000 Arkansas covered lives. So this is that example. And then here, this is part of the report required for plans with more than 5,000 Arkansas lives. So just to give you a kind of a quick snapshot of the type of information they're looking for. This is generally information that plans are going to need to get from their pharmacy benefit manager. They may not have this information on hand directly, but they need to get the information from the pharmacy benefit manager and then submit the report to the Arkansas Department of Insurance, according to the rule. So the scope of the rule, again, it applies to all health benefit plans with covered lives in Arkansas. The definition of health benefit plan is very broad. It includes any group health plan, policy, or contract for healthcare services. There is no exclusion for self-insured health plans governed by ERISA, which is what we would expect to see in a rule of this nature. There is an exclusion for federally regulated health benefit plans restricted from state regulation under federal law, but that language is a little bit vague. It's not entirely clear if they were intending to include self-insured health plans governed by ERISA in that exclusion, or whether they're thinking of something else with that exclusion. So without clear guidance on whether self-insured health plans governed by ERISA are included in the scope of this rule or not, we come to an ERISA preemption question. Is this reporting requirement interfering with National Uniform Plan Administration? Is it seeking to regulate a key matter of plan administration? Again, these are kind of the key questions that we ask under that impermissible connection piece of the ERISA preemption analysis. This law has not yet made its way through the courts. We don't know for sure how courts would handle this ERISA preemption analysis if it comes to that. But I think it's an important question to keep in mind as we see laws like this coming up across different states. And I think, on its face, the report itself may not be terribly onerous. Again, it's information that the pharmacy benefits manager should provide to the plan. But if you can imagine every state having a similar reporting requirement with its own specific provisions being requested, its own timing requirements, its own submission requirements, that can get pretty onerous on plan administrators in a hurry. So while one state doing it may not seem like a problem, if 50 states do it, it would be a problem. So we'll have to kind of wait and see how this plays out. Moving over to Florida. Florida has Senate Bill 1550, or the Prescription Drug Reform Act, that again also kind of popped up recently in the last few months. It requires pharmacy benefit managers operating in its state to turn over claim reimbursement data for every prescription drug filled within the state of Florida. So it's not looking for de-identified or aggregate data. It's looking for actual specific claim reimbursement data. It's looking for the claimant's name and date of birth. So very sensitive, protected health information and very private information is being requested under this law. In addition, it includes kind of a wide array of restrictions on contracts between pharmacy benefit managers and plans. As an example, it precludes any sort of limiting the network to affiliated pharmacies, to pharmacies affiliated with the pharmacy benefits manager. It also limits and prohibits any requirement for using mail order pharmacies. This is not by any means an exhaustive list of the restrictions that the law includes, but just to give you an idea, a lot of the restrictions have to do with network adequacy for participants. So this law is pretty significant and maybe in some ways a little bit more concerning than what we're seeing in Arkansas. And like Arkansas, though, it raises the ERISA preemption questions. Is this interfering with National Uniform Plan Administration for plans that have participants in Florida? Is it seeking to regulate a key matter of plan administration? Alongside that, we also have HIPAA compliance concerns. A self-insured health plan should have HIPAA privacy and procedures, privacy and security policies and procedures in place. Is permitting this sort of claim reimbursement data, which is PHI, is that permitted under the plan's policies? Is it permitted under the business associate agreement that the plan has in place with the pharmacy benefits manager? So these are very important questions to consider if your plan is faced with a request under this law. I think there's also a lot of uncertainty with this law about how the state agency is going to be collecting the information. I think there's a lot that needs to be clarified in that regard, as well as how the state's going to be holding the information once they get it. Again, that HIPAA focuses on all of those details of privacy and security, and we want to make sure that any governmental authority requesting an information is abiding by those requirements as well. So again, Florida and Arkansas are not the only two states that have laws that are kind of raising some of these ERISA preemption questions, but they're just kind of two examples that we think are helpful to keep in mind. At the federal level, legislation has not been quite as exciting as it has been at the state level. There is a law that's been drafted, although there hasn't been a lot of movement on it yet. It's called the Hidden Fees Disclosure Act of 2025, and it would require an annual fee disclosure from pharmacy benefit managers and third-party administrators. It's drafted as an amendment to ERISA. So ERISA Section 408B2 requires annual fee disclosures from service providers. So far, most pharmacy benefit managers and third-party administrators are claiming they're not subject to this requirement, that they don't meet the specific language described in this statute. So this law would sort of close that loop and really bring them into that annual fee disclosure requirement. Again, nothing's really happened. This law has been drafted, but it hasn't gone up for a vote. It hasn't gone to committees yet. So it's a ways out, to say the least. There have been a couple of executive orders from the Trump administration focusing on prescription drug pricing. So again, kind of a different angle of prescription drug regulation, but if this is sort of becomes a unified priority on the legislature and the administration, we might see a little bit more movement on this Hidden Fees Disclosure Act. So we'll have to wait and see on that front. All right, and then moving to prescription drug litigation. There's been sort of three major cases in the last 18 months or so in which participants have brought suit against plan fiduciaries, arguing that these plan fiduciaries have failed to ensure prescription drug prices are reasonable under their plans for participants. And this is resulting, on one hand, in the increased monthly contributions or premiums that participants are required to pay to participate in the plan. And it's also resulting in just generally a high cost of prescription drugs purchased under the plan. An important caveat to this discussion is that each of these cases has involved a health plan that's funded by a trust, known as a VEBA, or a Voluntary Employees Beneficiary Association. So when a health plan is funded by a trust, that creates a clear sort of link to liability for breach of fiduciary duty under ERISA. Generally, most often we see self-insured health plans that are funded by general assets, and that provides some protection from these types of fiduciary breach claims. So don't panic as we talk through this litigation. Most plans are funded by general assets, and this is not directly applicable. But I think these cases are important just for keeping in mind sort of best practices for managing your health plan and your prescription drug program. So the first case filed, and the one that's kind of spent the longest time moving through the courts, is Lewandowski v. Johnson & Johnson. And there's been a motion to dismiss that both sides argued, and the case and the court has issued an order on fairly recently. So I thought it'd be helpful to kind of go a little bit more in depth on what this motion to dismiss entailed. The defense argued that the plaintiff failed to meet the constitutional standing requirements for the breach of fiduciary duty claim. As a reminder, the constitutional standing requirements a plaintiff has to show that there's been an injury, that the injury was caused by an action as the defendant, and that there is redressability in court, meaning that a court decision on the case would appease the injury that the plaintiff has incurred. The defense argued that there has been no personal injury to the plaintiff. The plaintiff chose to participate in the plans knowing what the costs were. And although the plaintiff had pointed to some prescription drugs that were higher under the plan than if they had been purchased outside of the plan, that in and of itself doesn't show injury if the plaintiff had not personally been prescribed those drugs that were too expensive in the plan or more expensive in the plan than they were outside of the plan. The plaintiff, in response, argued that there was standing, again, because the plaintiff had paid the higher monthly contribution rates, had paid for prescription drugs under the plan, and that she had generally been injured by these expensive plan costs. The court sided generally with the defense and dismissed the breach of fiduciary duty claim. They argued that the plaintiff's arguments were generally speculative in nature. It's hard to say that an employer or a plan could have gotten a better contract with a pharmacy benefits manager had it negotiated harder or had it gone to a different pharmacy benefits manager. And it's certainly hard to parse out particular provisions and say, oh, they should have gotten, this drug for this cost instead of that cost and so forth. So generally an argument that they did a bad job in establishing a contract is too speculative in nature to win on this argument. They also pointed to a lack of redressability. In this particular case, the plaintiff had exceeded the prescription drug cap under the plan every year. So the court held that any sort of reimbursement that was due would end up going to the plan for bearing the burden of that overpayment rather than to the plaintiff. So if there had been an injury, it wouldn't be resolved by holding in the plaintiff's favor in this case and awarding damages. There had been another claim that the plan had failed to provide documents upon request. That has not yet been dismissed. But again, I think it's good news for plan administrators that the court held as it did on the fiduciary duty claim. The other two cases that we're going to talk about, Navarro v. Wells Fargo is one. I just wanted to give you kind of a status update as to where these cases are. In Navarro v. Wells Fargo, a motion to dismiss was granted in March of this year, and an amended complaint was filed trying to kind of hone in on the fiduciary duty argument. So we're still kind of in the early stages of litigation on that case. And then in Stern v. J.P. Morgan Chase, a complaint was filed in March of this year, so a very new lawsuit. And a motion for dismiss was filed just a few weeks ago in June. And that has not yet been decided yet. So what can, and kind of in the face of this rising litigation over prescription drug plans, what can plan administrators and plan sponsors be doing to sort of protect themselves from litigation? Again, all of these cases so far have to do with plans that are funded by a trust and not by general assets, while the vast majority of plans are funded by general assets. But it's good to keep in mind some sort of best practices or things that you can do to protect yourself as this litigation continues to pop up. So one option would be to consider establishing a committee to administer your medical and prescription drug plans. And there's several different steps involved in that. You need a charter, you need to determine who sits on the committee and sort of how the committee functions. We don't see this in with every health plan, certainly, but some particularly larger employers are choosing to go this route as a way to protect their board from litigation. Another important step is simply to negotiate contracts. I know pharmacy benefit manager contracts are just notoriously difficult to negotiate. Not only are they very difficult to understand in the first place, but pharmacy benefit managers are not really open to negotiation, and a lot of it just kind of goes by the wayside, it seems. But if you can at least document that you tried to push for the best provisions you could for your participants, that can go a long way in protecting yourself and showing that you're upholding your responsibilities as plan administrator for your participants. Another step can be issuing requests for information or requests for proposals to sort of get a better benchmark as to how your plan costs line up, as to how what your costs would be with other pharmacy benefit managers. Any information you can get to help benchmark how your costs align and show that they're reasonable. I think everyone feels like their prescription drug costs are just crazy high right now. But if you can show, yes, they are high, but they're within the realm of what everyone else is paying, that's information you want to have. Again, we don't see a lot of luck with this, but if you can at least request a 408B2 disclosure, so this is the disclosure that's kind of at the heart of the federal legislation we talked about, requesting that annual fee disclosure from your pharmacy benefits manager. They probably won't give it to you, but if you can document that you at least ask for it, again, it can go a long way to showing that you're doing everything you can for your participants. And that brings us to our first secret word, which is ocean. So please correct the answer from the choices listed below. And I'll give everyone a few seconds to do that. So again, today's first secret word is ocean. Please select answer A, ocean, from the choices below. And we'll give everyone just a couple more seconds. Again, today's first secret word is ocean. All right, our next topic is mental health parity. Like prescription drugs, there's been a lot of movement on mental health parity in the past year. We saw the issuance of the 2024 final rule a little bit less than a year ago. And then just a few weeks ago, it was kind of pulled back by the agencies. And so now plan administrators are kind of left trying to figure out where they stand. So that's what we're going to be talking about today. So just kind of a bird's eye view of mental health parity and how it came into being. It sort of took shape over 3 different pieces of legislation in the late 90s and the early 2000s. A few years after the passage of the Patient Protection and Affordable Care Act, we got the 2013 final regulations, and up until that point, most of the mental health parity requirements that we've talked about had to do with quantitative treatment limitations. So limitations like things like deductibles, co-payments, visit limits, things like that, certain requirements in your plans, and making sure that there was parity in those requirements as they apply to mental health and substance use disorder benefits and to medical surgical benefits. So these are kind of your easily, if you have a $25 co-payment for outpatient medical visits, but a $200 co-payment for mental health visits, that's kind of a clear indication that there's a lack of parity. And those are, kind of distinctions that are relatively easy to see in a plan. But then towards the end of 2020, we had the passage of the Consolidated Appropriations Act of 2021. And that included a new requirement to have what's called a comparative analysis for any non-quantitative treatment limitation in your health plan. And a non-quantitative treatment limitation is something like step therapy or prior authorization requirements. So it doesn't have to do with a payment amount, but it has to do with sort of different obstacles that can arise in a plan that limits coverage of treatment under the plan. A few months after the Consolidated Appropriations Act was passed, the tri-agencies, so the Department of Labor, the IRS, and HHS issued FAQ Part 45, giving a little bit more detail as to what they were looking for with this non-quantitative treatment limitation comparative analysis. And then the agencies worked very hard to get the 2024 final rule issued a few months ago, at the end of 2024. However, shortly after the final rule was issued, in January of this year, the ERISA Industry Committee filed suit challenging various provisions of the 2024 rule. Of course, in that time since the 2024 regulations were first issued and the start of 2025, there was also a change in administration. In February of this year, the Trump administration issued an executive order kind of generally pushing for deregulation among federal agencies. So citing that order, the tri-agencies, which again is the DOL, the IRS, and HHS, asked that the litigation be held in abeyance while they reconsider the final rule. The court agreed, and a few days later, they issued sort of their formal statement indicating that we were in a period of non-enforcement for the 2024 final rule. They do characterize it as a temporary period of non-enforcement, so it will go until there's a final decision in the litigation, plus an additional 18 months. So we're in a little bit of a holding pattern. The litigation is on hold until the department sort of reconfigure the 2024 final rule. And then once the 2024 final rule is reconfigured or revised or whatever they decide to do with it, then the litigation can resume. Once the litigation ends, then there's another 18-month window. So all of that said, this is probably going to be a longer temporary period of non-enforcement, but the agencies were careful to say that it's not going away entirely. And then what does this mean? In their statement, they were clear that this only applies to anything that was new in the 2024 final rule, and everything up until that point still applied. They're encouraging states to take a similar approach to non-enforcement, as states are sort of charged with mental health parity if it applies to fully insured health plans. So again, what does this mean? Sort of bird's eye view. Everything that we've kind of known about mental health parity still applies. It's just that the 2024 final regulations do not apply. In other words, the comparative analysis requirement that was set forth in the Consolidated Appropriations Act of 2021 still applies and still is required of plans. So any group health plan that has both medical surgical benefits and mental health and substance use disorder benefits and has any non-quantitative treatment limitation applying to mental health or substance use disorder benefits must have a comparative analysis for each one of those limitations. This must be made available to the tri-agencies and state authorities upon request, and this requirement has been in place since it first kind of became effective in February of 2021. I think a big question for a lot of us is how much the tri-agencies are going to be requesting this comparative analysis during this period of non-enforcement. And so that's something we're kind of waiting to see how active they are in requesting this analysis. We don't have a lot of guidance on that yet, but it is important for plans to still have a comparative analysis on file. Even if it's not perfect, have something on file so that if you do get one of the agencies sort of knocking on your door, you have something to give them. The law gave a little bit of an indication as to what it's looking for in the comparative analysis. It wants to see the specific coverage terms under your plan that include this non-quantitative treatment limitation. It wants to see a description of any factors or evidentiary standards used in applying the non-quantitative treatment limitation. It wants to see an analysis as to how the limitation applies to mental health and substance use disorder benefits on the one hand and to medical surgical benefits on the other hand. And it wants to see findings and conclusions as to whether that limitation as applied is aligned with mental health parity, if there is parity in how it applies to mental health and substance use disorder benefits and as it applies to medical surgical benefits. FAQ Part 45, again, this came out in April of 2021, shortly after the Consolidated Appropriations Act was passed. It includes a little bit more detail and is maybe a little bit more user-friendly. It's sort of discussing what the tri-agencies are looking for in the comparative analysis. So it's similar information, it's just broken down a little bit more. It also discusses what sort of documentation the agencies are going to be looking for if they request your comparative analysis. So all of these supplemental documents are things that the agencies might be asking for in addition to just your comparative analysis itself. And then who can request a plan's non-quantitative treatment limitation comparative analysis? The tri-agencies, they're going to be mostly focusing on self-insured health plans, state authorities, which are going to be focused on the fully insured health plans. And FAQ Part 45 does note that participants and beneficiaries can technically ask for this as well. This is not something that we see happen often, but again, it just kind of drives home the point that it's important to have some comparative analysis in your files ready to hand out if someone asks for it. In all of the reports to Congress that we've seen from the tri-agencies on their enforcement of mental health parity up until this point, they've noted that any comparative analysis they've requested has not been perfect. Everyone they've looked at has had some sort of flaws. And the Consolidated Appropriations Act did not include any financial penalties or other penalties for plans for having an imperfect comparative analysis. So, it's not that what you have on file has to be perfect, but I think if you have something and then if you have to supplement it as needed, it's easier to start from something than from nothing. So have something on file if you can. Have it on file sooner rather than later. And then if one of the agencies asks for it or if a participant asks for it, you have at least a baseline ready to go. All right, and with that, I will hand things back over to Mike to talk about Qualified Education Assistance Plans.
Okay, great. Thank you, Amy. So Qualified Education Assistance Plans are something that has seen a lot of interest lately as the expenses relating to higher education continue to grow faster than inflation and faster than the wages of most folks in the workforce. Folks are looking at these types of employer programs as a way to attract and retain talent within their organization, given the high cost associated with getting a higher education in the U.S. these days. What is new is that the IRS has weighed in with some FAQs and a fact sheet just about a year ago that, while largely in line with prior guidance under the code and the regulatory regime that applies to education assistance plans, what we're seeing here is sort of the first formal guidance that we've got as it relates to the student loan program that was rolled out a few years ago under Qualified Education Assistance Plans. So in these FAQ documents, they reiterate that a plan document is required in order to get the tax benefits for your employees and participants in these programs. That has to be separate and has to be a written document. What the IRS has done in the recent guidance is provide some sample language that you can use to adopt one of these types of programs. Now, that's probably not something that you're going to want to use as is. It's probably a good starting point, however. Employers have choices on exactly what they want to offer to their employees in terms of education assistance. And oftentimes they put guardrails in place to limit the types of programs that a particular employee might be able to seek reimbursement from the employer on, in terms of both the content of the program of study, for example, or in terms of the quality of their performance. Some of these programs require employees to get a particular grade or better in order to qualify for reimbursement. This IRS sample document is sort of similar to what we've seen in the market with some vendors that have samples that, again, might be a good starting point for you to think about how you want to design one of these types of programs, but might not be something that you want to just take at face value and push out without making some edits to it. So in a Qualified Education Assistance Program, what are you allowed to reimburse an employee for? You can reimburse for tuition. That can be graduate study or undergraduate study. It's not limited under the code to work-related education, although some employers do limit their programs accordingly. And employers may want to think about what limits they want to impose on these types of programs. You can cover fees and similar expenses that are imposed by the institution for education, or you can reimburse things like supplies and equipment. What you can't reimburse under these types of programs are things that are related to meals, lodging, transportation, things that employees might purchase as a tool or a supply in their course, such as a laptop that they can use after they finish the course. You can't reimburse folks for courses involving sports, games, or hobbies unless that particular course has a reasonable relationship to the employer's business or are required as part of a degree program. And you can't reimburse expenses that are outside the express terms of the plan. As I've mentioned a couple of times, employers can determine the scopes of what their plan will or will not cover in a particular case. There is a dollar limit. You can reimburse up to $5,250 to your employees per calendar year, regardless of any plan year that you might have under your assistance program, or regardless of the particular course schedule that the individual might be following. What the IRS has noted in its sample program is that the expense must be incurred in the same tax year that the expense is reimbursed by the employer. That was kind of an interesting note coming out of this, because that's not something that is found in either the Internal Revenue Code or the regulations. So it's unclear why this particular provision was included as part of the sample. So some clarification on that particular point from the IRS would certainly be a welcome development as we think about moving forward with these types of programs. As I mentioned, it's not just tuition that can be subject to reimbursement. You can also provide reimbursement for repayment of qualified education loans. This is defined as a loan at an eligible education institution. It doesn't have to be issued or guaranteed under any federal post-secondary education loan program to be qualified as a qualified education loan. And the definition of eligible education institution is determined by the Department of Education under Code Sections 221 and 25A. So as far as the reimbursement for these student loan payments, currently there is a sunset. It's scheduled to expire at the end of this year. It started back in 2020. The payment from the employer can be made directly to the individual or to the loan servicer involved. It can cover principal or interest on the loan. And it must be expressly permitted under the terms of the applicable plan document that that loan payments are eligible for reimbursement under the plan. Important to note that it has to be for the employee's education and not for a spouse or a dependent, or it can't be used to reimburse a loan that was taken out by the employee's parents for the employee's education. Also of note, the underlying debt must be a reimbursable expense under Code Section 127, meaning that list of things like books, fees, and tuition, and it can't be a loan that is for things that are excluded, such as meals, lodging, transportation, or the like. So if you're interested in implementing one of these types of programs, you're going to have the employee substantiate for you that the loan at issue, or the portion of the loan at issue that you are reimbursing the employee for is sufficient solely on those Code Section 127 requirements. That may or may not cause some difficulty for employers in implementing these types of programs. So something to keep in mind if you're thinking about moving forward with one of these. Now, I mentioned that there is a sunset on this, currently set to expire January 1 of next year. But Trump's big budget bill that is slowly making its way through Congress would re-up this provision. And it would include other things that would impact education programs, including the dollar limit would be subject to an inflation adjustment. So that's going to be increased based on cost of living for the calendar year, and that inflation adjustment is going to be rounded to the nearest multiple of $50. That provision would be effective as of 12/31 of this year, allowing this program to sort of continue if this is included as part of your program. And one thing that I wanted to mention in terms of the plan document, the requirements of the plan document specifically refer to education loans. In our experience, you know, it depends on what the plan says. Plans generally refer to current education, not to loans, or a blanket reference to Section 127 and anything that might be able to be covered under that section. But arguably, if your plan document provides that anything that's eligible for reimbursement under 127 is covered, it would include these student loans. So employers may want to review that program language depending on whether or not they're interested in reimbursing their employees for qualifying student loan repayments. In terms of other things that the Trump budget bill is potentially going to do, just something to keep an eye on as this thing moves forward. It's possible that it would include changes to allow medical care to include certain things like physical activity, fitness, and exercise. So like gym memberships could be covered by anything that generally consists of qualified medical care, things like HSAs, things like flexible spending accounts, to include those as something that can be reimbursed tax-free under a medical program. It would allow both spouses to make catch-up contributions to the same health savings account, and it would allow for an increase in the health savings account contribution for certain individuals. So something to keep an eye on as this budget bill winds its way through Congress, potentially towards enactment. And now Amy and I will open it up for any questions on any of the topics that we've covered today. Oh, looks like we need to do a secret word first. Today's second secret word is flower. So please select the secret word from the choices below. Again, the secret word is flower. Give folks just a moment to go ahead and make their selections from the list here. Again, the secret word is flower. As you complete this portion, if there's any questions, please put them in the chat. We'd be happy to answer them, or feel free to follow up with either of us by email. You folks have yet to answer the secret question, which is flower. All right, and with that, seeing no questions, I'm happy to wrap this up. Thank you for participating in the webinar. Please complete and submit the survey that will display at the conclusion of this webinar. Thank you for your attendance.